Hello, thanks for taking the time to watch today. My name's Kevin Crowley. I'm an attorney here with the firm of Lane, Hupp & Crowley, and today I'd like to talk to you guys about criminal damage. Criminal damage is, I think, one of the more common offenses that we see here at the firm. It's charged in a wide variety of circumstances and can come with a wide variety of penalties attached to it if there's a conviction. So criminal damage, what it basically boils down to is, did you break something that's not yours, and did you break it recklessly? Coffee cups thrown into walls and shattering in hotel rooms, holes punched through doors, alarm clocks, plates, photos, phones. There's another category of criminal damage though. And that usually occurs when somebody's in a vehicle, has an accident, and causes damage. So the key here, again, is recklessly. Was the damage caused recklessly? So now I'd like to tell you about a case that we had, a vehicular case regarding criminal damage. In this case, the vehicle was actually found unattended, but it had clearly run over a fire hydrant. The fire hydrant was underneath the vehicle. The water was spraying up into the air right behind the vehicle. It didn't take Sherlock Holmes to figure out what had happened there. Our client was charged with hit and run and criminal damage in that case. We actually went to trial in this matter, and our client was found not guilty because nobody could actually say that he caused the damage or whether it was done recklessly. There were no witnesses to the accident, so nobody could say that it appeared he was driving in a reckless manner. There were no witnesses to say that he was even the driver at the time. So based on that, the court found that there was a lack of evidence to prove beyond a reasonable doubt that our client was guilty. So how do you end up getting charged with criminal damage? Well, first off, the officers have to find that the elements of the offense has been met. Now, how do you recklessly damage something? You recklessly do it by ignoring an obvious risk. Okay? And if you ignore that obvious risk and you deface or damage the property of another, then you've committed criminal damage. One more issue that comes up in this, especially in DV cases, domestic violence cases of criminal damage. Now, domestic violence is simply an allegation added to other offenses based on the relationship between the person who is accused and the person who is the alleged victim. Usually it's some sort of romantic or familial relationship. In those kinds of cases, oftentimes the alleged victim and the defendant are married. They own the property together. So if it's a plate that they bought together in Arizona, that's community property, and they both own it. So if a spouse breaks a plate, can they be charged with criminal damage? And the answer to that is yes, because the other spouse has a property interest in that plate because it's community property. So be aware that even if you own something, it could be considered community property, and it could be considered criminal damage if you break it. Another way to cause criminal damage is to tamper or substantially impair the value of a thing. You can damage the property of a utility, like an electrical substation, things like that. One of the more unusual ways to commit criminal damage is to park a vehicle in a way that blocks cattle from having access to water. I've never seen that one. I doubt you're going to be my first. If you are charged with one of these offenses, the classification of that offense is going to vary based on the amount of damage caused. Any damage caused in an amount over $10,000 is going to be a Class 4 felony. If it's the property of a utility, it only has to be $5,000 to be a Class 4 felony. Anything over $2,000 is going to be a Class 5 felony. Anything between $1,000 and $2,000 is a Class 6 felony. And between $250 and $1,000 is a Class 1 misdemeanor. Under that is a Class 2 misdemeanor. So depending on the value of what is damaged, that is going to cause the classification to change. Because you can have such a range of different classification, there's a giant range of penalties as well. You could, for a Class 2 misdemeanor, have up to 4 months in jail imposed on you by the judge. But for a Class 4 felony, you could go to prison for 7 years. So obviously there's a wide range of possible penalties, and you need to talk to somebody about what you're facing exactly to determine how you want to go about defending that. Here at Lane, Hupp & Crowley, we have a lot of different novel ideas on how to defend cases of criminal damage. So if you want a smart, intelligent defense, please give us a call here at Lane, Hupp & Crowley. We'd be happy to speak with you regarding your charges. We look forward to hearing from you.